Good morning, everyone, and welcome. We'll call the hearing back to order. I think we have some preliminary issues that we need to take care of. I think we've got a couple of witness stipulations that we need to do, and then whatever else needs to come up. I think y'all have had some issues or discussions with Mr. Stark, so I think we got with Vote Solar. You want to go ahead and let's get that done, Mr. Cully?
We're on. Good morning and happy Monday, Mr. Chairman. Appreciate being able to take care of this right off the bat. So there was agreement among parties to waive cross of Mr. Barnes, and as part of the stipulation with the company, we had agreed that his oral testimony, the entirety of his oral testimony, including commission questions from the DEC case, could be taken notice of and incorporated in the record here, and his pre-file testimony in that previous case. But for now, would like to request that the pre-file testimony, which was his direct and surrebuttal, be entered into the record as if he were here present and giving it from the stand.
Mr. Barnes' pre-file direct and surrebuttal testimony will be entered into the record as though given orally from the stand.
And for the record, he had a verification that was filed on April 8th, so that is in the docket.
Do have that listed.
Okay, great, thank you. Mr. Barnes also has two exhibits that accompany his pre-file direct, JRB 1 and 2, and two exhibits that accompany his surrebuttal, JRB 1 and 2, surrebuttal 1 and 2. And would ask that these be marked, identified as a composite hearing exhibit, and I will approach the court reporter.
Okay, we'll enter Mr. Barnes' surrebuttal exhibits 1 and 2 as hearing exhibit number 32.
Okay, thank you, Mr. Chairman. And then as a last matter, would like to ask that Vote Solar be excused. We have no further cross during this hearing, and have consulted with counsel for NAACP, Coastal Conservation League, and Upstate Forever, that if any procedural questions arise, we will adopt their position.
You are excused.
Thank you very much.
Thank you. Okay. Mr. Guile. Okay. We're going to get this stipulated in, and then we'll procedure with you, Mr. Anthony. Thank you.
Good morning, Mr. Chairman, members of the Commission. Likewise, parties have agreed, and the hearing officer has approved this morning the receipt of Sierra Club's witness, Dr. Ezra Hausman's testimony, and waiving his appearance. So, Mr. Chairman, at this time, I would ask the Commission to accept Dr. Hausman's direct and surrebuttal testimony into the hearing record as if given orally from the stand. And, Mr. Chairman, his direct testimony consists of some 27 pages, but includes both a public and a confidential version. And we'd ask that the confidential version remain treated as confidential. And his surrebuttal testimony, consisting of 6 pages, is only in a public version, and there are no confidential elements to it. And so at this time, we'd ask that his testimony be accepted into the record as if given orally from the stand, and that his appearance be waived. He's likewise submitted a verification that's in the record.
Okay, thank you. Dr. Hausman's pre-file direct testimony, including the public, the public will be entered into the record will be read into the record as though given orally from the stand. That was more of a mouthful on Monday morning than I wanted to start with. And then the confidential version of his testimony will be held under seal. We'll also enter Dr. Hausman's surrebuttal testimony. It will be, his pre-file surrebuttal testimony will be entered into the record as though given orally from the stand.
And Mr. Chairman, Dr. Hausman also had a series of exhibits to his direct testimony, numbering 1 through 11. And of those, numbers 2, 3, and 4, 6, 7, and 10 are identified as containing confidential information. We ask that those exhibits for Dr. Hausman's direct testimony be accepted into the record as the next hearing exhibit, maintaining the confidential designated elements thereof.
Okay, Dr. Hausman's exhibits, the public exhibits 1, 5, 8, 9, and 11. They all be the same. We're going to do it separate for the confidential. Okay, we're going to do the confidential version first, which is 2, 3, 4, 6, 7, and 10 will be entered as exhibit number 33. And then the public version, the public exhibits 1, 5, 8, 9, and 11 will be entered as exhibit 34. Correct? Okay.
Thank you, Mr. Chairman.
Thank you. Mr. Anthony.
Thank you, Mr. Chairman. Good morning, Commissioners. Senior moment on Friday, I failed to offer into evidence the stipulation entered into by Duke Energy Progress and Nucor filed on April the 1st, so we asked that it be identified as a hearing exhibit. I guess we're up to 35.
Okay, the stipulation between Duke Energy and Nucor will be entered as exhibit number 35.
Thank you.
Senior moments are accepted here. So. Any other preliminary matters that we need to do before we start? And I think, okay, if we don't, I think all parties have agreed that we'll hear Mr. Parcell this morning. So ORS, if you will.
Yes, ORS calls to the stand Mr. David Parcell. Mr. Parcell, please state your full name and occupation for the Commission.
My name is David Carson, C-A-R-S-O-N, Parcell, P-A-R-C-E-L-L. I'm a principal with Technical Associates Incorporated, and I'm an economist and a cost of capital witness.
And are you the same David Parcell who pre-filed 59 pages of direct testimony in this docket on March 4th, 2019?
I am.
Do you have any changes, edits, or corrections to pre-filed direct testimony?
I do not.
And if I asked you the same questions today as those contained in your pre-filed direct, would your answers remain the same?
They would.
Mr. Chairman, ORS asks that the pre-filed direct testimony of Mr. Parcell be read into the record as if given orally from the stand.
Mr. Parcell's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Thank you. And Mr. Parcell, did you file as an attachment to your pre-filed direct testimony 2 exhibits marked DCP-1 and DCP-2?
Yes.
Do you have any changes, edits, or corrections to either of those exhibits?
I have one. On DCP-2, Schedule 4, the first column of that schedule is labeled year. And the last year stated in that column says 2009 or 2009. That should be 2019, 2019.
Thank you, Mr. Parcell. Mr. Chairman, may I approach the court reporter with...
Yes.
Mr. Chairman, I've just handed Ms. Court Reporter the 2 exhibits, DCP-1 and DCP-2. I'd ask at this time that those 2 exhibits be marked for identification and entered into the record with the correction as noted by Mr. Parcell.
Mr. Parcell's exhibits DCP-1 and 2 with the correction on exhibit 2 completed will be marked and entered into the record as exhibit number 36.
Thank you. And Mr. Parcell, did you also prepare 20 pages of surrebuttal testimony in this docket, which was filed with the Commission on March 25th, 2019?
Yes.
Do you have any changes, edits, or corrections to your pre-filed surrebuttal testimony?
No.
Mr. Chairman, ORS would ask that Mr. Parcells' pre-filed surrebuttal testimony be read into the record as if given orally from the stand.
Mr. Parcells' pre-filed surrebuttal testimony will be entered into the record as though given orally from the stand.
Thank you. And did you file as an attachment to your surrebuttal testimony one exhibit marked surrebuttal DCP1?
Yes,
Do you have any changes, edits, or corrections to that exhibit?
I do not.
Mr. Chairman, may I approach the court reporter one more time?
Yes, sir.
Mr. Chairman, I've just handed the court reporter Mr. Parcells' surrebuttal exhibit DCP1. I'd ask that it be marked for identification and entered into the record as the next hearing exhibit.
Mr. Parcells' surrebuttal exhibit DCP1 will be entered as exhibit number 37.
Thank you. Mr. Parcell, have you ever testified before the South Carolina Public?
Mr. Bateman, is there a copy of the summary?
Yes, sir. We do
We
have
go ahead
summary.
and get those now, so we won't be spazzing out while it's
Yes, sir.
a bit later. Thank you.
Mr. Parcell, have you ever testified before the South Carolina Public Service Commission?
Yes, I have.
When was that, please?
The first time I testified was in 1982. And since that time, I've testified in between 20 and 25 cases, some electric, some natural gas distribution, some telephone, and water.
And will you please provide the commission with a summary of your education and experience in utility regulation?
Yes, it's in DCP-1 is my curriculum vitae, and also page 1 and 2 of my direct testimony.
Thank you. And did you prepare a summary of your direct and surrebuttal testimonies filed in this docket?
Yes,
Would you please present that summary to the commission?
certainly. I've been retained by the South Carolina Office of Regulatory Staff, or ORS, to evaluate the cost of capital aspects of the current filing of Duke Energy Progress. I perform independent studies and am making recommendations of the current cost of capital for DEP. In addition, since DEP is a subsidiary of Duke Energy Corporation, I have also evaluated DE in my analyses. My overall cost of capital recommendations for DEP can be summarized as follows. A capital structure comprised of 47% long-term debt and 53% common equity, a cost rate of long-term debt of 4.16%, a cost of common equity of 9.1 to 9.5%, an overall cost of capital or rate of return of 6.78 to 7.00%. The first step in performing a cost of capital analysis is the development of the appropriate capital structure. I have used the capital structure as proposed in the company's filing in my analyses. The second step in a cost of capital calculation is a determination of the embedded cost rate of long-term debt. I have adopted the updated cost rate for long-term debt, that is 4.16% of DEP, as proposed in the company's rebuttal filing. The third step in the cost of capital calculation is the estimation of the cost of common equity, or ROE. I have employed 3 recognized methodologies to estimate the ROE for DEP. Each of these is applied to a group of proxy utilities similar to DEP and DE, as well as the group of electric utilities used by DEP witness Robert B. Havert. These 3 methodologies in my findings are discounted cash flow, 9.10%, capital asset pricing model, 6.45%, comparable earnings, 9.50%. My recommendation for DEP focuses on the results of the DCF, midpoint of 9.1, and CE, midpoint of 9.5 analyses. I recommend the midpoint of this range, or 9.30%, as the ROE for DEP. In my direct testimony, as well as my rebuttal testimony, I also discussed the cost of equity recommendation of DEP witness Robert B. Heavert. In his direct testimony, Mr. Heavert recommends a ROE of 10.75%. I demonstrate that each of Mr. Hevert's ROE methodologies overstates the appropriate ROE for DEP. The primary differences between my 9.3% ROE recommendation and Mr. Hevert's 10.75% ROE recommendation are as follows. 1. With respect to the DCF method, Mr. Heavert only considers a single source of growth, earnings per share forecast, in his single-stage DCF. In contrast, I consider several indicators of growth estimates. In his multi-stage DCF, Mr. Heavert focuses on historic measures of GDP, or gross domestic product growth, which is inconsistent with his refusal to consider historic growth in his single-stage DCF. 2. With respect to the CAPM method, Mr. Heavert uses interest rate projections as the risk-free rate, whereas I use current interest rates. It is noteworthy that Mr. Hevert's risk premium measure greatly exceeds the historic level of risk premiums. As for the CE method, Mr. Heavert does not employ CE as part of his analyses, whereas I do. This third method of analyzing an appropriate ROE for DEP considers the opportunity cost of capital investment. Finally, my direct and rebuttal testimonies observe the fact that Mr. Hevert's 10.75% ROE recommendation in the current proceeding exceeds every ROE award in the continental United States since at least 2016. This fact is evidenced in Mr. Hevert's exhibit RBH-6, included in his direct and rebuttal testimonies. Coupled with his selecting among the highest growth rates and use of EPS forecast in his DCF analysis, it is apparent that Mr. Hevert's recommendation is biased in favor of the company. Given that the average ROE authorized by state regulatory agencies for electric utilities has fallen from 10.32% in 2007 to 9.56% in 2018, it is my recommendation that the ROE for DEP in this proceeding be set at 9.30%. And this concludes my summary.
Thank you, Mr. Parcell. Mr. Chairman, Mr. Parcell is available for questions from opposing counsel and the commission. Thank you.
Thank you. Okay. For Cross, Walmart.
Good morning.
Good morning.
How are you? Mr. Parcell, can I direct you to your rebuttal testimony at page 19, line 20?
Page 19, line 20 of my rebuttal?
That's correct.
I have that, yes.
And so am I to understand your testimony that you believe one of the most comparable companies to Duke is Virginia Electric and Power Company?
To Duke Energy, yes.
And
Or at least Duke Energy Progress and Duke Energy Carolinas, yes.
you think that's most comparable to Virginia Electric and Power Company in Virginia?
Yes.
And turning to footnote 6, which I believe you indicate going on to page 20, you note that Virginia Electric and Power Company's currently authorized ROE is 9.2%. Is that correct?
Yes, that was established in 2018.
Bear with me just a second. I want to pull that case number. Do you believe that that was set in case number PUR 2017-00038 from the Virginia Commission?
I could check that, or I'll accept that.
Mr. Chairman, I would ask that the Commission take judicial notice of the Virginia State Corporation Commission's final order in PUR 2017-00038.
Okay, we will take judicial notice.
Mr. Parcell, are you familiar with that final order?
Yes.
And I think that you note in your testimony here that that Virginia Electric and Power Company has a currently authorized ROE of 9.2%. Do you recall that the Virginia Commission actually said that the cost of equity was 9.0%, but due to statutory language set it at 9.2%?
Yes. As a brief background, there's a statute in Virginia that states that the Commission can set the fair rate of cost of equity for utility as long as it's not greater than, not less than, the average earned return on equity for southeastern electric utilities. And they eliminated the bottom and top outliers to get that median to do that. So the Commission actually found in the last year's case that your ROE should be 9.0, but the statutory lower limit was 9.2, and that's where they went.
And I think earlier this morning, I think you testified that you, like Mr. Hebert, did your analysis based upon a proxy group of companies. Is that correct?
That is correct.
Could the Commission review? Let me back up. Am I correct that oftentimes the proxy group companies are not themselves utilities?
Yes, in a sense that the proxy group utilities, since they have to be publicly traded, they tend to be holding companies. For example, if I was involved in a case somewhere and Duke Energy Corporation passed my screens, Duke Energy Corporation would be a proxy company, not Duke Energy Progress, for example.
Okay, so in general, the proxy group companies are publicly traded companies, but then there are utilities that are governed very often by state regulatory commissions that are awarded a return on equity by those commissions. Is that correct?
That's correct. There's probably 3 or 4 total publicly traded utilities that are not holding companies in the United States. Almost all of them are holding companies.
So could we, would it be fair to look at what I'm going to call the subsidiaries or the utilities that are within the proxy group companies identified by Mr. Hebert, and to look at the returns on equity that other commissions have granted those utilities to determine a fair return on equity?
Well, the answer is yes, and that's what I've done in my testimony. in my direct testimony on page page 15, I did just that. And in my rebuttal testimony on page 5, I did that. Those are authorized returns on equity for individual utilities. For example, Duke Energy Corporation is a holding company, but it's got Duke Energy Florida, Duke Energy Carolina is in 2 states, that's 2 more. Duke Energy Progress is in 2 states, that's 2 more. Duke Energy Kentucky, Ohio, I believe that's these. So, I mean, Duke Energy, for example, would have as many as 6 or 7 individual authorized returns on equity.
So you agree with me then, I think, that we could look at the ROEs actually awarded to those utilities to get a feel for what the cost of equity is for the proxy group companies themselves.
I would like to restate that, if you don't mind.
Please.
I think we could look at that to determine what the authorized ROEs have been in recent years based upon the records of those utilities in the rate cases they litigated and or settled. So the then current conditions reflected in those, so you can see trends over time, and then there has been a downward trend.
May I have a document marked for identification? Mr. Parcell, would you take a look at the document that I've just handed you?
Yes.
And could you confirm for me whether you agree or disagree that the companies listed in column 2 are in fact subsidiaries of the proxy group companies listed in column 1?
Well, without verifying each individual instance, I can say that what you've shown me here are the holding companies of Mr. Hevert's group in column 1 and their individual subsidiaries in column 2. So I think that's your question. If it is, the answer is yes.
And then subject to check, you don't disagree with the ROEs that are set forth in column 3 or the date of the decision set forth in column 4?
Just check a couple that happened, cases that I happen to have been in, just for a sanity check here. The cases I'm familiar with are accurately reflected here.
Mr. Parcell, I understand that you have recommended a 9.3 ROE in these proceedings. Is that correct?
That is correct.
And I think that you understand that Walmart witness Chris has not done independent analysis but has provided information regarding nationwide trends on ROE. Do you agree with that?
Yes, I do.
Do you have an opinion on whether nationwide trends are trending upwards or downward on ROEs for vertically integrated utilities?
I don't quite understand your question. Maybe you left the word out.
Let me try to rephrase it. Do you have any opinion on whether ROEs are trending upwards or downwards for vertically integrated utilities nationwide?
Yes.
Can you tell me what that opinion is?
Yes. In my testimony, I've shown all utilities, but not just vertically integrated. The same source I used to develop page 15 of my direct and page 5 of my rebuttal. That same source can be used to look at authorized returns of equity for vertically integrated utilities. And I have that document with me.
No, this is more just a general, as an expert. I'm just looking for your opinion. Do you believe that ROEs are trending upwards or downward?
Downward.
Tell me why you believe that.
I was. I was trying.
I just want you to try to explain it without sort of, I just want you, in your own words, to sort of explain why you believe that ROEs are trending downward.
There's two reasons why returns on equity have moved downward over the last several years, or at least since the Great Recession started in 2008. The first reason is that interest rates are much lower now than they were then. And whereas rates went up a little bit in the first several months of 2018, they've dropped in the last few months such that they're lower today than they were a year ago. So interest rates have come down. The second reason is that regulated utilities and the commissions who regulate them have established a series of regulatory mechanisms, riders, tariffs, regulatory assets, deferrals, etc., which have changed the nature of regulation. The percentage of revenues that commissions establish through rate cases is less than it used to be because these riders, etc., are taking on a larger role now. And that means that the likelihood of under-recovery of costs is less than it used to be. And that's been recognized by the rating agencies, and it's also been recognized by the same commissions who add these riders, say, well, cost of capital is going down as well. So those are the two main reasons.
So just to summarize, I think number one is interest rates have gone down, and number two, mechanisms are in place to decrease regulatory lag.
Yes.
Are there any circumstances that you can think of in the last 3 to 5 years where you have really seen commissions awarding increased ROEs, such as what we see here, where Duke Energy Progress has requested an increase in its ROE from 10.1 to 10.5?
I've seen plenty of instances where the company asked for an increase, but I have not seen instances where it's been granted.
Thank you, Mr. Parcell. Your Honor, I would ask that the document that I previously requested be marked be moved into the record as an exhibit.
We'll enter it as Exhibit 38. Okay. NAACP, SCCCL, and Upstate Forever. Thank you, ma'am. Sierra Club.
No questions. Thank you, Mr.
Thank you. Energy Users. Thank you. Nucor. Okay. Company. Thank you. Commissioners. Commissioner Urban.
Thank you, Mr. Chairman. Mr. Parcell, good morning.
Good morning.
Based upon your analysis, do you have an opinion on Progress Energy's market risk relative to other vertically integrated electric utility companies? Or in other words, are they more at risk or less at risk than the average company?
But if by market risk you mean the total risk of the company in its operations, the answer is yes. Yes, I do have an opinion. Duke Energy Progress has its senior debt rated AA2. Actually, I have a number about that. In the United States, there are approximately 125 electric utilities, and these are individual utilities. For example, Duke Energy Progress and Duke Energy Carolina would be different. Of just 125, only 11 have AA ratings, and Duke Energy Progress is one of those 11. So it has higher debt ratings than most other utilities, and that is one indicator of risk. In that regard,
that rating would indicate to you that they are not at great financial risk. In fact, it means that they have excellent ratings.
It's a very good rating. There are, like I said, very few AA rated utilities anymore.
In the top 10%?
Yes, 11 out of 125. Yes, definitely top 10%.
Is that a factor that a commission should consider when looking at return on equity?
Yes, I mean, risk is a factor to be used in assessing the ROE. And a lower risk company requires a lower return on equity than a higher risk company.
What importance would you put on debt risk relative to other factors to be considered? Is it equal weight or greater weight or less weight?
Well, a lot of factors go into risk. I mean, the company's operations, its capital structure, and that's the good thing about bond ratings and for publicly traded companies, the other security ratings. Everything is considered. It's the rating agency's job to identify all the company's risk when it establishes the ratings for these companies.
So that's already it's baked into the cake, so to speak.
It's baked in the cake. Thank you. Exactly.
All other factors, all relevant factors.
They're required to do so, and they take great pride in doing so.
Thanks, sir.
Thank you. Any other questions, commissioners? Any redirect?
No redirect, Mr. Chairman. And Mr. Parcell has a flight to catch early this evening. We'd ask that he be excused.
Okay, thank you. Mr. Parcell, thank you for being here. You may step down and you are excused. Okay, back to Ms. Smith.
Yes, sir, Mr. Chairman and members of the Commission. We had one matter we wanted to round out from Friday before putting on the rest of our witnesses. The ORS and the company have continued to talk through the weekend and have reached maybe a constructive path forward on the non-allowable issue that was discussed on Friday, and I'd like to walk you through where we are on that and certainly invite ORS to follow if they have any questions. So on Friday, when we spoke about the concept of non-allowables in this case, it's not just the items from the list that were discussed that you saw on Friday. It's a longer list. Okay. And so when you look on the ELMO, this is I'm using a quote here, but the non-allowable bucket, with the things that we are and have been disagreeing on when we walked in the door on Friday. I hope that makes sense. So you'll see that we're continuing to litigate issues like coal ash, some of the other things on this item, on this list. So there's testimony about all of these items that has been filed and heard by the Commission in this case. And so the ORS and the company have not been necessarily in 100% agreement about what meets the definition of a non-allowable expense. But for the purposes of this case, we've been able to resolve some of our differences. And I'd like to walk through what those are. So following the discussion on Friday, the company has agreed to withdraw its request for recovery of the items in yellow. So that would be other miscellaneous items, $112,000, $736,000. Other employee recognition and award, $39,532. So that's what the company has offered to take out. Through other discussions with ORS, we've reached other resolution. I admit it's a little bit hard to read here, but the ORS has agreed to no longer contest the line worker rodeo. That's an amount of $26,231. Allocations not 100% related to South Carolina. This is related to transmission trucks, et cetera. That's $4,066. And accrual and timing differences of around $12,366. As well as we have agreed for purposes of this case to split the service and safety awards. That would split in half the amount of $31,655. So for purposes of efficiency and moving on with the case, that's the accord that we've reached. And again, I welcome ORS, after me. But in doing so and in making these concessions, we don't want the Commission to think that we are trying to get away with any unjustifiable charge. The company does remove charges that we believe should not be charged to customers, things like golf and alcohol. The company has not and will not argue that those types of items should be charged to customers. Occasionally, very few of those items may get past the review, and we very quickly agree to remove them, like you saw on the spreadsheet on Friday. Or in some cases, there will be a charge pulled, but not the corresponding correction reflected, like the Omaha Steaks. In fact, the aggregate dollar of the value of the items in dispute on Friday was $160. And our team has looked closely at all of those light items and was ready to speak, but that witness just wasn't Ms. Mettler as she was testifying to human resource philosophy versus the detailed transactions. But that doesn't matter. Again, we want to move forward with the case and want the commission to understand that several of those items we're not pushing forward for recovery. Other things may look different. For example, there was a Tony's Oyster Bar charge, and that was a meal for 4 traveling employees. It just looked like a bar. So we do believe that we may continue to have these disputes on these kinds of items based on principles. We, along, I believe, with ORS, would support an administrative docket to resolve some of the conceptual issues around non-allowables so that parties may have greater clarity going forward and that we can try to eliminate these types of issues from rate cases. It's important to note that these kinds of expenses occur over millions of lines of data, and anything that helps with clarity should yield process improvements for all. We continue to think that meals for traveling employees, modest tools for employee engagement, etc., are important to our operations. But we also acknowledge that we need to have a better way of providing more context when these charges are audited so that a more detailed explanation is available to ORS earlier. That includes both more information from our side and us taking more time in discovery to research the nature of the charges that are identified, since sometimes those explanations aren't easy to pull. So that's one improvement we can provide in the future. We also note that 6 of the items that were removed from the list on Friday, ship sticks, golf, those kinds of things, originated from our wholesale group. It is not our intent for retail customers to pay those types of costs, and going forward, we have put in place a direct assignment protocol for that group so that the ORS and frankly the Commission and us and everyone here won't have to deal with those manual removal issues or explanations going forward. We hope this is satisfactory to the Commission and parties, and we look forward to an administrative docket should it please the Commission. And with that, I'll be happy for ORS to speak, unless there's any questions for me.
Thank you, Ms. Smith. Go ahead, Ms. Edwards.
Just briefly, we appreciate the company working with us over the weekend. Just to put it out there very bluntly, ORS, we have an audit team, and we have a list that's called non-allowables. And this list, when the audit team is looking through the general ledger of the company, we're using a list that was developed over decades and decades of commission orders. In fact, when the commission staff, Jackie Cherry, and some of you may remember when the commission staff came over to ORS, some of the accounting, auditing staff at the commission, they brought with them that list of non-allowables that was just developed over decades of rate cases. And so it may be time to sit down and have a refresh of what should be considered a non-allowable expense that should no longer be passed to customers. And in particular, I can give you one good example, the safety awards. ORS drew from that from a prior commission order. I don't remember the exact date, but I can tell you it was probably well before 2005. And so that's on our list. That's just an item on our list of non-allowables. Some items are still in dispute, as you can see. For example, Party City. I mean, I don't want to mislead anybody. When we do have this administrative proceeding, you're probably going to hear from ORS, hey, look, we don't think customers should be paying for what others, you know, the utility might argue is employee morale enhancing or, you know, creating a nice work environment. These are some things that we will probably continue, and certainly we would argue in any administrative proceeding that some things should not be passed to customers. In this case, for this bucket, my understanding is the party city, those items out of this bucket, those are in the other miscellaneous, and that those are out. What is still in dispute is, again, we have a commission order on Chamber of Commerce and whether or not you have a professional organization like EEI, which those dues will go through, or you may have a social organization like Rotary. We go by past commission precedent, past commission orders, and that's what we apply. But again, I think an administrative proceeding, and that was one of the key components of this stipulation, is that the utility would agree with us to put this before the commission in an administrative proceeding, and let's just refresh the list. Let's take a new look at something that's actually been in place for a very long time. And with that, unless there's other questions, I believe Commissioner Howard asked the question of why is this still before the commission now? I'd say two reasons. One, in the past we had settlement agreements. And number two, this utility in this case has taken a position about the coffee and about, the baby shower, the party stuff. We've not seen that before. That's just something that's been specifically raised in this case. And I think that's the only answer I can give you on that one.
Thank you. Okay, thank you. And we will talk about that, and I think that'll be a good idea to hash that out and get some, because we spend an awful lot of time in this large dollar case on coffee and stuff. Okay, any other questions, commissioners? All right, back to the company.
Mr. Chairman, the company calls Mr. Karen and Dr. Wright as a panel. Good morning, Mr. Karen. I'll begin with you. Will you please state your name and business address?
John F. Karen, 411 Fayetteville Street, Raleigh, North Carolina.
By whom are you employed and in what capacity?
I'm employed by Duke Energy Business Services. I'm the Vice President of Operations, Maintenance, and Governance for the Coal Combustion Products Group.
Did you cause to be pre-filed in this docket on November 8, 2018, 38 pages of direct testimony in question and answer form, and an appendix consisting of 38 pages, and 10 exhibits consisting of 451 pages?
I did.
Do you have any changes or corrections to that direct testimony or exhibits?
I do not.
If I were to ask you the same questions that appear in your direct testimony today, would your answers be the same?
They would.
Did you also cause to be pre-filed in this docket on March 18 of this year, 25 pages of rebuttal testimony in question and answer form?
I did.
Do you have any corrections or changes to that rebuttal testimony?
I do not.
If I were to ask you the same questions that appear in your rebuttal testimony today, would your answers be the same?
They would.
Mr. Chairman, Mr. Karen also presented supplemental testimony, and upon consultation with ORS, the company is withdrawing that supplemental testimony. And Mr. Chairman, at this time, I would move that the pre-filed direct and rebuttal testimony of Mr. Karen be copied into the record as if given orally from the stand, and that Mr. Karen's exhibits be marked for identification and entered into evidence.
Mr. Karen's pre-filed direct and rebuttal testimony will be entered into the record as though given orally from the stand, and his exhibits, Appendix A plus Exhibits 1 through 10, will be entered as Exhibit number 39.
Now, Dr. Wright, will you please state your name and business address?
Julius A. Wright, president of J. A. Wright & Associates. My address is 18 Edgewater Drive, Cartersville, Georgia.
I believe you just said it, but again, by whom are you employed and in what capacity?
President of J. A. Wright & Associates.
Did you cause to be pre-filed in this docket on November 8, 2018, 28 pages of direct testimony in question and answer form and one exhibit consisting of 16 pages?
Yes.
Did you cause to be filed in this docket on February 11, 2019, an errata to your direct testimony?
Yes.
Do you have any changes or corrections to that direct testimony?
No.
If I were to ask you the same questions that appear in your direct testimony today, would your answers be the same?
Yes, they would.
Did you also cause to be pre-filed in this docket on March 18 of this year, 41 pages of rebuttal testimony and question and answer form?
Yes.
Do you have any changes or corrections to that rebuttal testimony?
I do not.
If I were to ask you the same questions that appear in your rebuttal testimony today, would your answers be the same?
Yes, they would.
Mr. Chairman, at this time, I would move that the pre-filed direct and rebuttal testimony of Dr. Wright be copied into the record as given orally from the stand, and that as one exhibit be marked for identification and entered into evidence.
Okay, Dr. Wright's pre-filed direct and pre-filed rebuttal testimony will be entered into the record as though given orally from the stand, and his Exhibit 1 will be entered as Exhibit number 40.
Dr. Wright, do you have a summary of your direct and rebuttal testimony?
Yes, I do.
Would you please present that to the Commission?
Yes. My direct testimony supports Duke Energy Progress's DE Progress request for
Hang on
recovery.
1 second. Do we have a copy of those? Okay. Sorry about that. Go right ahead.
That's okay. It makes great reading. My direct testimony supports Duke Energy Progress's DE Progress request for recovery of costs related to coal ash disposal expenses that the company has undertaken in response to new environmental regulations. Environmental compliance costs are similar to other costs a utility spends to produce and deliver power, as they are a necessary cost of providing electric service. Specific to coal ash disposal costs, the coal plants associated with these costs have been used and useful in providing low-cost, reliable power to South Carolina customers for up to 70-plus years. Consequently, these types of costs, and if any amount is deferred over time, a return would be appropriately recoverable in rates and consistent with how the Commission has historically allowed recovery of environmental expenditures. The last decade has seen an evolution in coal ash disposal regulations, beginning with the EPA's publication of proposed new regulations for coal combustion residuals, or CCR, in June 2010. In 2015, the EPA finalized those regulations, known as the CCR rule, which represented the first comprehensive federal regulation of CCR. The proposed and final CCR rule also strongly encouraged the states to adopt federal minimum criteria in their solid waste management plans. Accordingly, states in the region, including South Carolina and North Carolina, have developed their own regulations and policies for ash basin closure that complement the CCR rule. The fact that new standards have been established does not mean that DE Progress's past practices with regard to coal ash disposal were unreasonable. The company's decisions related to coal ash disposal must be judged in accordance with the regulatory standards and industry practice as it existed at the time. To that end, the company historically has complied with all coal ash disposal regulations and industry standards for its coal ash handling operations. Today, these rules have simply changed, and the company must now comply with these new standards. I conclude in my direct testimony that approval of the company's recovery request is appropriate because these dollars are required expenditures for compliance with new coal ash disposal requirements. My rebuttal testimony addresses several issues related to the recovery of costs associated with coal ash remediation expenses raised in the testimonies of OR witnesses Dan Whitliff, Michael Seaman Wynn, Willie Morgan, SCEUC witness Kevin O'Donnell, and Sierra Club witness Ezra Hausman. I also address general issues on the deferral of recoverable costs raised by ORS witness Zachary Payne. Taken together, the testimonies of OR witnesses Whitliff and Seaman Wynn recommend disallowance for ash basin closure costs for all activities that they contend were incurred solely to comply with North Carolina's Coal Ash Management Act, or CAMA. First, this recommendation does not align with the appropriate regulatory standard for denial of cost recovery, including recovery of environmental compliance costs, which requires a finding that specifically identified costs are imprudent or unreasonable. Neither ORS witness identified any specific cost as imprudently or unreasonably incurred. Second, this recommendation would overturn sound regulatory policy that system costs be allocated to the jurisdictions that are served. South Carolina customers have benefited from coal-fired generation of electricity for decades, and ash basin closure is a necessary component of that service. If accepted, ORS's recommendation would have a profound and lasting detrimental impact on the sharing of assets between South Carolina and North Carolina and the customers of both states. ORS witness Morgan recommends a disallowance of litigation expenses associated with alleged violations of environmental laws. It is my understanding that the company is not seeking costs associated with fines or penalties related to environmental violations, nor any legal expenses associated with them. Of the two categories of litigation costs identified by OR witness Ham for disallowance, one category does not relate to environmental violations at all, and the other category relates to ongoing litigation that the company is reasonably defending where there has been no finding of environmental violations. The company has an obligation to its customers to prosecute and defend those litigation matters, and the associated costs should be recoverable. ORS witness Payne recommends that the company not be allowed to earn a return on its deferred costs during a deferral period. For several deferred expenses, ORS witness Payne proposed longer amortization periods than DE Progress recommended. The Commission should reject the ORS's recommendation because it violates the regulatory compact in that it would not allow the company to earn a fair return on its deferred expenses and recover the full value of prudently incurred costs. SEUC witness O'Donnell recommends that 75% of DE Progress's environmental compliance costs should be disallowed based on a faulty comparison of alleged national asset retirement obligations, or ARO amounts relating to CCRs. The Commission should reject any disallowance, especially one as substantial as the amount Mr. O'Donnell recommends, that is not based on facts and evidence that have been proven and verified as substantially significant, and Mr. O'Donnell's flawed proposal fails this test. To do otherwise would constitute poor regulatory policy and would be arbitrary. In addition, Mr. O'Donnell presents an analysis in his testimony that he claims provides evidence that the company's CCR compliance costs are well above the CCR compliance costs faced by other utilities. However, as I show in my rebuttal testimony, Mr. O'Donnell's estimated CCR compliance costs for other utilities is old or dated information. Because of this, his cost estimates for other utilities' CCR compliance are very much understated as compared to more recent cost estimates, and this error makes his comparison invalid, notwithstanding the numerous errors in his analysis identified by company witness Karen. Sierra Club witness Houseman contends that the Commission should condition the company's recovery of coal ash costs on the future performance of a comprehensive retirement analysis of the company's coal power plants. Sierra Club's conditional cost recovery proposal should be rejected because it violates its accepted rate-making policy. It is a fundamental tenet of regulatory policy that utilities are allowed to recover their prudently incurred expenses, and Sierra Club has not shown that any of the company's coal ash costs are imprudent. This concludes my summary of my direct and rebuttal testimonies.
Mr. Kieran, do you have a summary of your direct and rebuttal testimony?
Yes, I do.
Would you present it at this time?
I will. My direct testimony presents Duke Energy Progress, DE Progress, request for recovery of expenses that the company has incurred between July 1, 2016 and September 30, 2018 to comply with the environmental requirements for the disposal of coal combustion residuals, or CCRs. DE Progress request does not include any costs that have been incurred related to fines, penalties, or guilty pleas related to CCRs, or any cost associated with events related to those fines, penalties, or guilty pleas. My testimony also presents Duke Energy Progress's supplemental request for recovery of CCR compliance costs occurred from October 1, 2018 through December 31st, 2018. CCR disposal regulations and industry practices have evolved significantly over almost a century of providing electric power service from coal-fired plants. During this evolution, DE Progress has consistently complied with the CCR disposal standards that were in place at that time. Based on industry developments that occurred in the 1950s, the enactment of the Clean Air Act in the 1970s and its amendment in the 1990s, and the enactment of the Clean Water Act in 1972, along with the creation of the National Pollution Discharge Elimination System, or NPDES permitting program, wet ash handling and ash basins were the primary lawful, effective way to meet CCR needs and environmental requirements in the years prior to the advent of today's requirements. In many cases, ash basins were actually created or relied upon to effectuate prior regulatory regulations. With each evolution of these environmental regulations, the company has changed how it's operated its coal-fired stations to comply accordingly. And at each step in the environmental regulatory evolution process, the company has been in line with industry standards and has reasonably, prudently managed CCRs in its coal ash basins. The latest evolution of these requirements, the Federal Environmental Protection Agency's CCR role, as well as state-specific regulations and oversight in the company's service territories, has occurred since the company's last rate case. DE Progress is now subject to new federal and state regulations that require it to take significant actions to modify its operations and, as a result, incur substantial new expenditures associated with those modifications. All of the company's ash basins must be closed under either the CCR rule, state-specific regulations and oversight, or both. All closure plans must be approved by the respective state agencies. The company has begun the process of closing or submitting plans to close its ash basins in accordance with its regulatory obligations. The actions and decisions that Duke Energy Progress has taken to comply with federal and state regulatory requirements, including the company's current and future activities and solutions, have been reasonable, prudent, and cost-effective given the individual characteristics of each CCR plant and basin site. My rebuttal testimony responds to the direct testimony of Office of Regulatory Staff, ORS, witness Dan Whitliff, and SCEUC witness Kevin O'Donnell. No witness in this case have challenged Duke Energy Progress's closure strategy for its ash basins under applicable federal or state regulatory requirements, nor have any witness in this case alleged that the company has taken actions that are unreasonable or imprudent. Instead, witnesses Whitliff and O'Donnell asked this commission to simply ignore the North Carolina Coal Ash Management Act, or CAMA, because it is too costly. Specifically, I disagree with the recommendations of ORS witness Whitliff that all compliance costs attributed to CAMA should be disallowed for the company's Asheville, Sutton, Cape Fear, H.F. Lee, and Weatherspoon sites. Like South Carolina and other states in the country, North Carolina has adopted environmental policies and preferences for coal ash disposal that complement federal closure requirements under the CCR rule. Duke Energy Progress is obligated to follow state regulations and is doing so in an environmentally responsive and cost-effective manner. The suggestion that South Carolina customers can enjoy all the savings of sharing power generation units within North Carolina customers, but ignore any compliance costs with valid laws would present grave harm to South Carolina customers if taken to its logical conclusion. I also explained that in addition to their misguided proposals to ignore valid CAMA cost, Mr. Whitliff's and Mr. O'Donnell's specific proposed disallowances are based on incorrect facts and unrealistic assumptions. First, I disagree with Mr. Whitliff's contention that Duke Energy Progress could have closed its ashfill basin by capping them in place, as opposed to its chosen method of excavation and off-site disposal, absent CAMA. Throughout his testimony, Mr. Whitliff also appears to conflate the cap in place and the excavation closure methodologies, at one point suggesting that an on-site landfill should have been constructed, while at the same time urging cap in place. I note that Mr. Whitliff has conducted no engineering analysis to support his conclusions, which render his recommended disallowance unsupportable. Mr. Whitliff's rebuttal testimony makes no attempt to resolve this lack of engineering analysis and his internal inconsistencies in his testimony. The company closure approach is the proper closure method based on site-specific and regional conditions. Second, I disagree with ORS witness Whitliff's erroneous conclusion that absent CAMA, the company could have left its ash basins at the Cape Fear plant untouched indefinitely because those basins are not covered by the CCR rule. The position that DE Progress could or would have taken a do-nothing approach for the Cape Fear units when similar basins at the South Carolina's Robinson and W.S. Lee stations that are also not covered by the CCR rule were being excavated is wholly unrealistic. I also explain how Mr. Whitliff has conveniently ignored the fact that the provisions in the federal CCR rule that he relies upon to support his do-nothing approach at Cape Fear site have been found to be arbitrary, capricious, and without factual support by the D.C. Circuit Court of Appeals and has been remanded to the EPA. Mr. Whitliff's rebuttal testimony doubles down on that do-nothing approach, again without concluding whether the do-nothing approach would have had been reasonable and prudent from an environmental and safety perspective. The lack of any reasonableness and prudence analysis is a flaw that pervades all of Mr. Whitliff's testimony. I also disagree with ORS Whitliff's contention that CAMA ash beneficial reuse ash recycling requirements that are associated costs from its DE Progress HF Lee and Cape Fear plants and Duke Energy Carolina's Buck plant are more costly to South Carolina customers than the federal CCR rule. In fact, CAMA's ash beneficiation requirements actually results in a net savings for South Carolina customers. And under ORS's proposal, those net savings would all need to be given to North Carolina customers only. Next, I disagree with Whitliff's contention that Sutton closure schedule under CAMA has increased costs for the customers of South Carolina. Mr. Whitliff incorrectly assumes that closure activities would not have been required until 2021 at Sutton under the CCR rule, and this is inaccurate. Mr. Whitliff's entire disallowance figure is dependent on his incorrect interpretation of the CCR rule. He compounds this error by assuming that over time, resources become cheaper as demand for them grows stronger. And this conclusion is logically unsound and factually incorrect. Mr. Whitliff was forced in his rebuttal testimony to acknowledge that closure under the CCR rule would have had to been completed by 2021, which means that, like Asheville, the closure timing at Sutton was not substantially affected by CAMA. This fundamental error makes his proposed disallowance for Sutton completely inaccurate. Regarding Witness Whitliff's recommended disallowance for the Weatherspoon, I disagree with his contention that his calculation of costs attributable to CAMA's beneficiation requirements should be disallowed. To be clear, Weatherspoon is not being beneficiated pursuant to CAMA. In fact, Weatherspoon does not even qualify as a beneficiation site under CAMA. Mr. Whitliff's uninformed observations while on a half-day visit do not somehow convert Weatherspoon to a CAMA beneficiation site. Furthermore, Mr. Whitliff has failed to recognize that the beneficial reuse of ash at Weatherspoon is saving, not costing customers more money. Lastly, I would like to note my strong disagreement with Mr. Whitliff's disallowance methodology, which attempts to determine recoverable and disallowable cost for each site by developing a weighted average percentage based on costs from different sites operating in different conditions. Disallowance for a given site should only be based on the analysis of actual costs incurred at that site and the determination that those individual costs were not reasonably and prudently incurred. Mr. Whitliff himself has admitted that the weighted average percentage approach that he uses here was too unreliable and unsupportable to use during his testimony in the North Carolina rate case. And in fact, that fact has not changed how he is in South Carolina. With respect to witness O'Donnell, his analysis recommendation of a 75% disallowance of Duke Energy Progress coal ash costs relies on multiple analytical flaws that are each fatal to his conclusion. Specifically, I do not agree with his conclusion that his national comparisons of CCR asset retirement obligations, or ARO, amounts that show Duke Energy Progress's ARO is overstated by 75%. I enumerate 22 factors that Mr. O'Donnell does not appear to have considered, which must be accounted for in order to seriously attempt this type of analysis. I explained that Mr. O'Donnell actually considered those factors. He would have discovered that his analysis was invalid. I recommend that the Commission consider the reasonableness of DE Progress's ARO amount on its own merits, based on the facts of this case, without regard to Mr. O'Donnell's speculative proposal. This concludes a summary of my direct and rebuttal testimony in this case.
Mr. Chairman, these witnesses are available for questioning.
Thank you. Walmart. Thank you. Ms. Ferguson. Okay, Mr. Guile. Hang on, Mr. Guile. Let's take a quick break first, and then we'll start with you when we finish. We'll take about 10 minutes.